helping with the technical issues. And our presenter is Dan Bryar, who I think this is the first time you're presenting with us, isn't it, Dan?
That's true.
And Dan is joining us to provide insight. I mean, so often we see legislation that is, when it first is introduced, everybody says, "What does this mean?" And we don't know what it means until quite a while later, when it's been gone through the process and has been enacted, and then the true meaning starts to become defined. Dan's going to take us down a journey of looking at the PRO Act 2021 and telling us what it looks like now, so we have a context for the conversations that we're going to follow as it gets debated in the Capitol and in the media. Dan is with the law firm of Hartnett, Bryar and Jones, and I'll let him talk a little bit more about his background before that. But I'm thankful to have you with us, Dan. Great topic. I look forward to to the presentation. At the end, you'll have time to take questions at the end.
Thanks very much, Doug. I appreciate the opportunity to be here with you this morning. As Doug mentioned, my name is Dan Bryar. I'm with the law firm of Hartnett, Reyes, Jones in St. Louis. Our firm practices traditional labor law, the sort of gamut of ERISA litigation for our labor clients, for plan compliance and stuff like that, as well as doing delinquency work to make sure contractors paying into multi-employer benefit funds. We also represent clients in the work comp setting and things like that. I've been with the firm since October of 2019. Prior to hello, I'm back. Prior to coming to work for the firm here in St. Louis, I spent not quite 10 years as a staffer in the Missouri General Assembly. I've been a legislative assistant, chief of staff for a state senator, and ran a political state senate race out in Kansas City. I worked on the House side as a legislative coordinator for the House Minority Caucus, and a couple of years as legislative director for the House Minority Caucus before coming to work here in St. Louis for the Hartnett, Reyes, Jones firm. Without much further ado, I'm gonna share my screen with you all, and there we are. And I'm gonna make this presentation big so we can just sort of start getting going here. The topic of conversation this morning, as Doug mentioned, is the PRO Act. There we go. So my plan here is to sort of give you an overview of the Protecting the Right to Organize Act, which is pending in the United States Senate presently. I think that for a couple of reasons, this is a good opportunity. Number one, if this legislation or some parts of it become law, we've spent some time thinking about what that means. But also, going through a large legislative proposal like this also allows us to sort of take stock as to where federal labor law is presently. So in that way, it sort of acts as a bit of a case law review and sort of where we're at. So I intend to sort of talk through some of the provisions of the act, how it'll change union organizing, and then maybe we'll speculate a little bit on whether or not it'll actually become law. As a couple of disclaimers, I'll probably refer to the act generally. That'll be referenced to the National Labor Relations Act, of course. I'll try to call out board decisions, when I can, when they're illustrative to illustrate a particular point. And then, I'll also try to juxtapose a little bit of current law as to what's proposed in the PRO Act. One more disclaimer, the version that I had a look at is called HR 842, and that's introduced by Representative Bobby Scott of Virginia, who's presently the chair of the Education and Labor Committee. There may be other versions of the PRO Act that are pending in Congress right now. that might be, slightly different or drastically different from the one that I looked at. But this is the one that passed the House, is what I'm going to talk through today. So it received a floor vote in the U.S. House on March 9th. It was 225 to 206 was the floor vote. Probably unsurprisingly, the bill passed on mostly a party line vote. There's 220 Democrats voting yes. There's one Democrat from Texas that voted no, and 5 Republicans that joined voting yes. And those folks hail from Pennsylvania, New York, New Jersey, and Alaska. Probably also unsurprising. If you skim the congressional record, the opponents generally would gripe that the bill didn't go through a regular process. It didn't go through the committee wrangling process. It just went straight to the floor. And then generally opponents will say, well, unions funnel billions of dollars to organizations like Planned Parenthood, the Clinton Foundation, progressive Democrats, and stuff like that. And that's bad. So we shouldn't have policy that encourages that kind of organization. And then, it'll generally upset, settled law and also invalidate state right to work laws. And that's a bad public policy. Proponents spend a lot of time reading in letters from various labor organizations who are engaged in this process and obviously lobbying for its active passage. So, if you look at the record, you'll see letters from the Painters Union, the AFL-CIO, Blue Green Alliance, American Federation of Teachers, and stuff like that. So let's sort of have a look here. From a big picture review, I'm going to talk through some definitional changes that are proposed in the Act, changes to unfair labor practice charges, changes to the election procedures, strikes, and then state right to work laws is sort of big picture where we're going here. So from a definitional standpoint, the PRO Act does a couple of things to change, who are joint employers, when are you going to have a joint employer relationship, who are supervisors, and when are they excluded and not going to be protected by the Act, and who are independent contractors and when they're not going to be protected by the Act. So these are fundamental questions over who receives NLRA protections, and they're generally fights over definitions of who is an employer, who is an employee, when does a worker really work for a joint employer, when is a worker really a supervisor, and these are all rewrites to the definition section of the NLRA. On the joint employer standard, a joint employer is basically when you've got two business entities that exercise or can exercise control over working conditions on the job. Typically this comes up in a franchisor and a franchisee relationship, or a contractor and subcontractor relationship, a staffing company or something like that supplies labor to perform work on a job site. So the question then becomes, in these situations, when you've got these relationships, when you're organizing a workplace or negotiating a contract or filing a ULP or something like that, who are you really dealing with? And when are you dealing with both the franchisor and the franchisee, or the contractor and the subcontractor? This is recent controversy caused by a case decided by the board called Browning-Ferris in 2015. Browning-Ferris dealt with a situation where you had a BFI recycling facility in California that utilized a staffing company called Lead Point. There's like 250 Lead Point employees and maybe 60 BFI employees in the plant. And, the BFI contract with that staffing company, was basically terminable at will. I think it was 30 days notice or something like that. And BFI really called a large number of shots on the job site. So there was an organizing campaign, and after the election, it was sort of like, who do you deal with? And the board in 2015, and this is the Obama board, ruled that when you've got two or more statutory employers, they're joint employers of the same employees if they share or co-determine matters governed by essential terms and conditions of employment. The right to control does not require exercise of the control. So the BFI had the ability to control terms and conditions on the job site. It wasn't necessary that they exercise that control on a daily basis or anything like that. It's enough that the control does exist for them to be found a joint employer and to be covered by the Act. Flash forward to 2020, you've got the Trump board that imposes a rule that basically says unexercised control or unexercised authority is probative, but only if it reinforces evidence of direct and immediate control. So you're only going to find a joint employer when you've got both business entities possessing and exercising substantial direct and immediate control over wages, benefits, hours, hiring, discharge, discipline, supervision, and direction. So the PRO Act's change to this sort of controversy between the Browning-Ferris and the present board rule sort of goes back to the Browning-Ferris decision and says that reserved control or reserved authority can be enough to find a joint employer status. And why is this important? Well, I think that proponents of the PRO Act would say it's important because you're going to bring the real employer to the table in an organizing campaign or when you're actually negotiating a contract and things like that. Opponents will say, this is the end and destruction of franchisor-franchisee relationship forever and all time. And I probably side on the side of seeing the PRO Act becoming law. So that's one definitional change that's proposed by the PRO Act. Moving on to the independent contractor discussion, this is another definitional change. The Act specifically excludes independent contractors for who is an employee under the Act. So the broader the definition of who is an independent contractor, obviously the fewer employees that are going to be covered by the Act's protections. The board's recently decided cases that basically make it easier to find an independent contractor. The board's 2019 decision in Super Shuttle DFW, is one example of that, where the entrepreneurial opportunity of contract drivers was enough for the board to find that they're independent contractors, not employees covered by the Act. Even more recently, the board decided a case called Velux Express and Janine Edge. They're the company, Velux was providing medical courier services. The employee, Janine Edge, who is a driver and classified as an independent contractor, was fired for raising complaints about treatment of the drivers and contacting an attorney to discuss the employer's route driver agreement. The ALJ in that case found that the drivers were not independent contractors; they were employees, and further found that it is an independent ULP under 8A1 of the Act for an employer to misclassify employees as independent contractors. They said that if the employer wrongly does so, that in and of itself is inherently coercive. The board reviewed that and said, well, yeah, Janine Edge is an employee. The employer shouldn't have fired her for raising complaints or contacting an attorney, but misclassification of employees as independent contractors alone is not going to be unlawful under the Act. And the board rationale rested on the employer's role in making legal determinations as to whether an employee or a worker is an employee or an independent contractor. And they reason that when the employer decides to classify workers, they are forming a legal opinion as to the status of the worker, which it can do under the NLRA, and the employer's opinion does not get less protection because it later turns out to be incorrect. So the board said it's not coercive, basically, to wrongly tell a worker that they're an independent contractor. And what does this mean for employers under the Act presently? Well, merely communicating a misclassification status to workers in and of itself is not a threat or reprisal of force or promise or benefit, and thus is not considered a violation and is not going to be a ULP. The PRO Act sort of addresses this situation in a couple of ways. First, it codifies what's called the ABC test, and that's a product of the California legislature attempting to codify a state Supreme Court case. And that would say that you're only going to have independent contractors when those individuals or workers are free from control and direction in performing services. And that's either via the contract or in fact, as the facts bear out how the relationship works. The contractor are performing services that's outside the usual course of the employer's business. It's not something that the business or the employer does all the time. It's something that's customarily engaged in an independently established trade, occupation, profession, or business of the same nature as that involved in the performed service. So that's one way that the PRO Act addresses the independent contractor situation. And the second is that it institutes a ULP, an unfair labor practice, for wrongly telling workers that they are not covered by the act. So that squarely addresses that recent board decision in Velux Express and Janine Edge. Just as a comment on the California sort of paradigm here that this embraces. Already you've seen in California under their state law, lobbying efforts to exempt various jobs and professions from that new statutory scheme. And you've also had the state initiative called Proposition 22, which legally designates drivers for app-based ride-hailing and delivery apps as independent contractors. So, the PRO Act proposes to, codification broadly of this ABC test. Whatever lobbying efforts existed in California after that enactment, I would bet all the money in my pockets are going to be similarly visited on Capitol Hill regarding this definitional scheme. And the third definitional change that I'll talk through is regards to who is a supervisor. So this is another definitional change of the act, and supervisors generally are not protected by the act. They're not going to be considered or included in the bargaining unit. So the more supervisors, the less workers that are protected by the act. I've got up on the screen, what the change is. That's the act as to who is a statutory supervisor presently, and then underneath the PRO Act's suggested change, and it would just say that supervisors are people that do things that supervisors do when they do them for a majority of the individual's work time. If you've got an individual that for the majority of their time doesn't act like a supervisor, they're not hiring, firing, transferring, laying off, disciplining or adjusting grievances, and then they're not a supervisor. An employer isn't going to classify them as such. So that's the present definition of supervisor, and the PRO Act's change just to sort of reorient and tighten that definition. The next sort of big topic under the PRO Act's changes are unfair labor practice changes here. And these are you offer fairly impactful proposals to the change of federal law presently. And we've already talked through one instance of how the PRO Act would change ULPs. We're going to talk through quite a few more. For the employer, the Act is going to increase ULP charges that can be cognized against an employer. Things like replacing strikers. We talked through communicating about covered status of employees, engaging in captive audience meetings, and then making unlawful class action waivers in handbooks and things like that. For unions, this or labor organizations, this is going to reorient ULPs as well. And the big takeaway is significantly proposing eliminating barriers to picketing, and then we'll talk through remedies which under the PRO Act are also extraordinarily robust. So for an employer, presently, as a threshold matter, it's not a violation to replace economic strikers or to lock out workers under certain circumstances. And that's generally, if the situation's, tainted by an unfair labor practice or inherently destructive of the right to strike. And, that inherently destructive phrase, that comes from a Supreme Court case in 1963 called Erie Resistor, which said it's a ULP for an employer to offer super seniority status to replacement workers and workers breaking up an economic strike. The court said that this is the Supreme Court, said that super seniority by its very terms operates to discriminate between strikers and non-strikers, both during and after a strike, and is a destructive impact upon the strike and union activity cannot be doubted. More recently, the board decided a case called Piedmont Gardens. And Piedmont Gardens sort of illustrates the kind of evidence that you need to show improper motive for replacing economic strikers. The strike, was called with notice given to the employer, which stated unconditional offers for strikers to return to work several days later. The company, in response, made arrangements for temporary workers, many of whom were given permanent positions later on. On the return date, several members were not permitted to return to work. The union attorney reached out to the management side and said, hey, this is a pretty big deal. Why is the employer permanently replacing these folks rather than just locking them out or trying to do something like that? And the management attorney replied that the employer wanted to teach the strikers and the union a lesson. They wanted to avoid any future strikes, and this was the lesson that they were going to be taught. So there's two reasons offered for replacing the economic strikers, and that was first to teach the union a lesson, and to avoid future strikes. Evidence also showed the permanent replacers was to avoid future strikes. Okay, so the board said that the permanent replacement of the strikers violated the act, and sort of laid down the rule that employers can permanently replace strikers, unless it's shown that in hiring the replacements, the employer was motivated by an independent, unlawful purpose. And in this case, an independent, unlawful purpose includes employer's intent to discriminate or encourage or discourage union membership. So, that the evidence that was out there in Piedmont Gardens, you're typically not going to get the opposing counsel to openly admit that they're hiring replacement strikers to teach the union a lesson. So, that shows one instance of when you might, find a ULP or inherently destructive taint, but generally it's going to be difficult. Under the PRO Act, it's an unfair labor practice to promise, threaten, or take any action to permanently replace striking workers. So, we're not worried about inherently destructive to the right to strike or tainted by ULPs or anything like that. It says it's a ULP to permanently replace striking workers, period. It's a ULP to discriminate against an employer participating in a strike or to lock out, suspend, or withhold employment to influence employees or their representatives in bargaining prior to a strike. So that's, offensive, an offensive lockout. It's also going to be a ULP. It's also ULP to communicate or misrepresent to a covered employee that such employee is not a covered employee by the act. We talked through this a few moments ago about that recent board decision on point. And it's also going to be a ULP to engage in, what's called captive audience meetings. And, I suspect there's folks on this call that have been participants to captive audience meetings. I've not been personally present to one. I think I've heard tape recordings of such, and this is generally a situation where, during an organizing campaign, management gets folks in a room and without any union members sort of rebutting any of the claims or anything like that, says, if you organize, if you become an organized workplace, we're moving out of town, everyone's going to lose their job, the sky's going to fall and stuff like that. So the PRO Act says these are going to be unlawful, and that's going to be a ULP. The PRO Act also, says that the PRO Act also instates communications. If an employer has a communication system or email service that employees can use, they can also use that for concerted Section 7 purposes. This is the remedies slide here. Okay, so the act, the proposed act expands what is going to be included as ULP. It also ratchets up or gives hammers to the board for how these things are going to be enforced. Presently under the act, you're limited in your remedies to, if somebody gets discharged, eventually you get them back to work. Maybe you get back pay with interest, and of course that's going to be reduced by intermittent earnings and stuff like that. So it's not a very strong or meaningful remedy presently under the PRO Act, especially when employers commit certain ULPs, including discouraging union membership, discriminating against employees for filing board charges or participating in board proceedings, or any ULP that results in discharge. The employer is going to be responsible for back pay, front pay, consequential damages, and liquidated damages up to 2 times the amount of damages awarded. So this is a marketable increase in what's at stake for a ULP charge. Additionally, presently board orders aren't self-affecting, and if the board wants to enforce a ULP charge, they basically got to go to the Court of Appeals to get that done. The PRO Act would suggest that if a board agent issues a complaint, or if a complaint issues, the board has the right to go to court and petition for a temporary restraining order, which shall be granted unless there's no reasonable likelihood that the board will succeed on the merits. So this is a pretty deferential standard, and allows the board to pretty quickly and immediately enforce a ULP charge. So the board decides there's a ULP, the complaint issues, the board's pretty well going to get a TRO. The PRO Act also outlines, $500 penalties for failing to display posters telling folks what their rights are and stuff like that. And, I should have mentioned this a moment ago, but ULPs, in addition to other remedies outlined, can also result in $50,000 for each violation, or $100,000 for each violation for discouraging union membership, discriminating against employees for filing charges, or any ULP that results in a discharge or serious economic injury. So those are pretty hefty fines. It also outlines a potential personal liability for officers and directors, and allows the board discretion as to when personal liability for officers and directors are going to issue. It also outlines a right of action where a court could similarly enforce remedies under the Act, and also provide attorney's fees for folks that have to go to court to institute a private right of action. It probably should be noted that the penalties outlined for the ULPs, the 50 grand or the 100 grand for each violation, those are penalties that get sent to the government. It's not a windfall to an individual employee or the labor organization or anything like that. And one of the other things I'll mention is that the PRO Act would outline these remedies apply regardless if a worker is an unauthorized alien or not. And this amendment to the Act is necessary due to a Supreme Court case called Hoffman Plastic Compounds, and that's a case from 2002, and that's a 5-4 U.S. Supreme Court decision which denied an award of back pay to an undocumented worker named Jose Castro, who'd been laid off for participating in a union organizing campaign, along with several other employees. I had in my notes here the dissent expressed concern that employees' use of the lack of immigration status of the employee to relieve themselves of responsibility under the Act. I think in retrospect that's extraordinarily well taken, and not covering unauthorized folks under the Act only encourages or has a tendency to encourage potential exploitation of labor. So what does the Act propose for unions in the way of unfair labor practice charges? Well, it generally eliminates many of the unfair labor practice charges that might be assessed or charged against a labor organization. Those broadly relate to secondary picketing, recognitional picketing, jurisdictional pickets, and hot cargo agreements. When you look through the actual text of the act, you see broad swaths removed from 8B4 and 8B7 entirely. Practically, under the PRO Act, labor organizations are going to be able to picket against companies that do business with a primary target. So secondary pickets and stuff like that is going to be perfectly legal. And whereas today the employer could petition file a complaint and have the board petition the district court for an injunction. That's not going to be the case under the PRO Act. And relatedly, the act eliminates the necessity for 10K hearings, eliminates the ability of employers to petition. We talked about that for injunctive relief for secondary pickets, and also eliminates standing to sue for an 8B4 ULP. So the next big topic that we're going to talk through that's substantive change to federal law under the PRO Act relates to elections, and these very well may be some of the most impactful changes. The changes to the ULPs, beefing up the enforcement prospect of ULPs, is a marketable change in federal law, but these election proposals are also fairly substantive. So the PRO Act substantially would institute, what was the Obama board election rules. You've got a pre-election hearing that's not later than 8 days after a notice of hearing is served on the labor organization. Employers got 2 days after notice of petition for election to post notices. You've got to keep them up, throughout the duration, unless the petition's pulled or replaced by a notice of election. Regional directors are going to have to schedule elections as soon as practicable, but not later than the 20th business day after the direction of election. These are the quickie election rules that I think folks may be familiar with from having visited with some of this stuff just a couple of years ago. It also says post-election hearings are going to be conducted not later than 14 days after filing objections. The act, or the PRO Act, also recommends codifying some election bar language, 12-month election bar, 12-month filing of bargaining order, and stuff like that. The PRO Act also suggests that ULPs that are filed by labor organizations will suspend the processing of a petition unless the board determines that employees can exercise free choice despite the unlawful conduct alleged. So, if there's an organizing campaign, certification, decertification, whatever, and there's a ULP that's filed, the wheels sort of come to a halt, and before the board can determine that the election can go forward. So that's certainly a guardrail to conducting an election that might be tainted by an unfair labor practice charge. The PRO Act also has some pretty significant changes to a unit configuration analysis. On the slide there, we've got just a citation to PCC Structurals and the Boeing Company. Presently, when a petition for certification, gets filed, the employers, one of the first, moves in the tool bag is to sort of say that the petition for a unit is inappropriate in one way or the other. And they look at whatever you petition for is inappropriate under those couple of recent cases, PCC Structurals and the Boeing Company. The recent example of Amazon, illustrates, the problem dynamic for a petitioning campaign here. The campaign at Amazon petitioned for 1,500 employees, and they ended up with an election of 5,800 or close to 6,000. And this is a marketable change from the 2011 Obama board. They issued a decision called Specialty Healthcare that basically gave preference to the bargaining unit's proposed unit. And under specialty healthcare, if the unit asked for by the union or the labor organization had a community of interest, and the employer wanted a different unit, then the employer had to show that the proposed unit has an overwhelming community of interest with the union the group that the union petitioned for. The 2017 decision with PCC Structurals and the Boeing sort of flips the determination on its head, and has the board evaluate the proposed unit from the other angle, and makes the union or labor organization very closely justify the appropriate unit that they've petitioned for, and practically this just makes petitioning for a unit much more difficult. And I was talking with Doug at the before everyone signed on. One of the things that, or one of the problems that this poses is, let's say you petition for a group with 10 guys in it, or 10 members in it, and the employer says, well, there's another 30 folks that need to be included in the bargaining unit, and the board sort of goes for the larger unit. Well, do you even have the cards or the showing of interest to proceed to election? In a lot of cases, maybe you don't, and you sort of have to go, back to the drawing board, or talk to a group of folks at an employer's shop, or site that you hadn't even visited with beforehand. So under the PRO Act, the proposed unit is appropriate, basically with a return to the decision in specialty healthcare, and that's a big change. It's hard to wonder what the outcome would be in the Amazon election if the unit that went to election was the smaller unit, but here we are. The other thing that the PRO Act proposes is that employers don't have standing to intervene in representation elections. So it's going to be basically the board's decision, unfettered by an argument by an employer that that a wall-to-wall unit or a larger unit should be the one that goes to election, rather than what was petitioned for. Finally, the board directs where and how the election's held, and there's going to be an opportunity to do electronic voting and stuff like that. And I think they've got 90 days after the enactment to implement a electronic voting system to do so.
Okay.
So moving on to other representation election changes under the PRO Act. I've got up there the Excelsior list. That comes up from a 1966 board decision, and that's basically the employer's got to come forward with the names of folks that are going to be included in a bargaining unit certification election. In 14, under the Obama board, there was a rule that said the employer's got to provide all available email, home address, and numbers directly to the union, 2 business days after a direction of election. At the time, opponents raised a lot of concerns that this violates privacy for folks in the bargaining unit that might not want to have that information released, and it also created burdens on an employer for having to find all numbers or emails that might apply to an employee and stuff like that. In 2019, the board moved to unwind that rule. They sent out a request for information, and a letter from the regional director committee to the board, Chair Kaplan at the time, this is back in April of 2018, said, while parties initially voiced great concern about the 2014 election rule, to all parties' credit, after the initial learning curve, there have been very few difficulties in the adoption of the rule. So the 2014 board rule, that made for the quick dissemination of information to the labor organization or petitioning party, in reality hadn't been that difficult for folks to comply with. Essentially, the PRO Act returns to the 2014 board rule, and would codify that standard for information for folks that are going to participate in a certification election. Oops. The PRO Act also changes who can participate in a certification election. Basically says that folks that are engaged in a strike of any kind, not necessarily an economic strike. So if you've got ULP strikers, they can, codifies that they can participate in an election. After an election where you've got a majority vote, certification comes with a board order to proceed directly to bargaining without the need for determination of any kind of ULP. So if a labor organization gets a certified vote, you're going right to bargaining. And in a case where there's not a majority vote, the board will consider filed ULPs in a post-election hearing, and the employer's got the burden to demonstrate that the violation or interference claimed of in a ULP during the campaign was unlikely to have affected the outcome. The board shall, without ordering a new election, set aside the election and certify the labor organization. So they've got an ability to certify the labor organization just by determining the scope of the ULP that was submitted under the PRO Act. So that's a big change as well. Obligations to bargain after you've got a certification. The PRO Act says that employers must maintain wages, hours, terms and conditions of employing pending an agreement. The duty to bargain absent certification is continual following a certification election. So impasse and unilateral implementation by an employer is substantially curtailed and potentially eliminated by the PRO Act's broad mandate to continue to bargain. The employer loses the ability to unilaterally implement terms less than would be agreeable and loses the opportunity for offensive lockout. So it really takes away a pretty substantial economic weapon on the employer's side. And the PRO Act also implements changes for a first contract. So a first contract following certification, there's pretty specific rules that the parties have to meet and bargain 10 days after notice. 90 days after the first hearing, either party can request a federal mediation mediator. 30 days after that FMCS request, the parties can be referred to interest arbitration. And if the first contract does go to interest arbitration, there's going to be a panel that outlines a 2-year contract based largely on economic factors. So if the first contract situation sort of deadlocks over the course of a few months, there's an ability to refer the first contract conversation to interest arbitration, and that panel is going to outline the terms and conditions of employment for 2 years, and it's largely based on, like I said, economic factors, and that includes the employer's financial status and prospects, size and type of employer's operations, employees' cost of living, employees' ability to sustain themselves, their families, and their dependence on wages and benefits they earn from the employer, and the wages and benefits from employers in the same businesses provided their employees. So that interest arbitration, provision and that first contract provision is pretty significant. And when you consider that in a lot of cases it's very difficult to get to a first contract after a certification. Board orders. I think we touched on this a little while ago. Enforcement, by an administrative agency, is about only as strong as how willing regulated parties are going to be with complying with laws and orders. The Economic Policy Institute, outlined a study that says that employers are charged with a ULP in not quite half of union elections, 41.5% of elections, and had a study that said that 1 in 5 elections involved a charge where a worker was discharged for engaging in union activity. So, there's clearly a cost-benefit analysis that's done there that says that in certain circumstances, an employer is willing to catch a ULP charge or discharge a worker, that might very well be a ULP in an organizing campaign, because the penalties just aren't that stiff. There's clearly a cost benefit analysis there. I've got up there on the slide a KRS contractors example, and this is a situation where a union organizer applied for a job at a non-signatory contractor. The contractor said, "Hey, look, we don't hire union workers." And on the application, why don't you go ahead and give me 3 references, which wasn't a pattern or practice that was required by other applicants for the job. ULP was filed against the New Jersey contractor. And this just sort of outlines the timeline for presently how board orders get enforced. In May of 2018, a complaint issued. The contractor didn't answer. In February of 2019, the labor board granted a default judgment against the contractor because he didn't respond to any of the process by the board. In April of 2019, the Third Circuit enforced the default judgment. The board moved to enforce the Third Circuit's judgment in district court. So you've got this back and forth between district courts and appellate courts to just try to get the default judgment award enforced. In April of 2020, the board moved for contempt. And in February of 2021, the district court granted the contempt motion and instituted a daily fine for non-compliance by the contractor. That's February of 2021 versus a complaint that was first issued against the contractor for a ULP in May of 2018. The labor board processes seriously limit the remedies that are available here, and that's presently. But under the PRO Act, it says the board doesn't have to go to the Court of Appeals to enforce its orders. The board orders are self-enforcing and effective unless modified by a superseding order. It also institutes $10,000 violations that get recovered by the board in a civil action. So the contractor in the KRS situation, would essentially have been on the hook for $10,000 a day violations for failure to respond to the board's order, versus 3 years later, a federal district court trying to, or maybe considering enforcing contempt sanctions for failing to follow an order. So this is a marketable and serious change to federal labor law. I've got up here the persuader rule. This is certainly a less impactful change, but just like union officials have to file LM forms, the PRO Act would codify a proposed but not enacted a DOL rule that would make employers file robust disclosures as to the consultants and advisors that they take on and pay in a union avoidance campaign. And just like some information on LM form might create fodder for opponents of an organizing campaign, I think that the amount of money that employers shell out for union avoidance campaigns might similarly create fodder in that similar sense. Strikes. Under the, presently, when you read some of the cold hard text of the act as it exists, might lead you to believe that strikes are lawfully protected, and sort of always is the case. Board law shows you that multiple kinds of strikes are not protected by the act. You think of slowdowns or sympathy strikes. Intermittent strikes, currently can be unlawful, but are very effective. I'll talk through that for just a minute here. An intermittent strike, of course, is a situation where employees withhold labor, for 1 day, or, here and 1 day there, and seemingly occur at random times. This can be very effective because it's, often not anticipated by the employer and stuff like that. The board recently decided a case called Walmart Stores. That's 2019. It stemmed from a nationwide campaign. In October of 2012, about 60 workers went on strike for 1 to 3 days in LA. In November of 2012, about 100 workers around the country struck for another 1 to 2 days. And in May and June of 2013, 130 workers struck for 5 to 6 days. In November of 13, there was a nationwide strike that involved, an unspecified number of workers, basically. The outcome of those strikes were that 54 workers were disciplined or discharged for participating in the November 2013 strike. ULPs were filed. The board found that the strikers' conduct was unprotected. These intermittent strikes were unprotected under the Act, despite the fact that the workers that participated were not union employees. So there wasn't like a no strike clause that they were violating under a CBA or anything like that. There were months where no striking occurred at all. Only a small percentage of employees participated at all. Some workers only struck once, so it wasn't like they were part of an organized campaign of doing it on day 1 and day 10 and day 12 or anything like that. And there was found to be no serious harm that resulted to the employer. But despite all of that, the board stated this random economic warfare deprives employers of their responsive defense of permanently replacing strikers. So presently, if intermittent strikes, they're not going to be protected unless you're sure that the strikes are over different issues and make it obvious that a ULP strike is specific to an issue, 1, and issue 2, and issue 3. The unprotected nature of the folks in Walmart seemed to stem from the fact that they were part of one organized campaign. That seemed to be the fatal element there. But under the PRO Act, you read some of the same language, and it augments that and says, the duration, scope, frequency, or intermittence of a strike shall not render the strike unprotected or prohibited. So that pretty well says that the kind of conduct, certainly the kind of conduct that was engaged in by the employees in the Walmart case, would be protected, and other even more aggressive intermittent strikes would certainly be protected as well. And we talked about this a little while ago, but also it's a ULP to replace strikers or engage in offensive lockouts as well. So that really solidifies the right to strike and reinforces it under the PRO Act. I've got marked up here a fair share agreements. I think that likely all the Missourians on this call are subject matter experts at this point, and what a right to work state law does and does not do after the 2000 the referendum in 2017-18. So under the PRO Act, basically right to work laws are going to be invalidated. And again, that's a large portion of the opposition to this. Is a call about state control and local rights and federalism and stuff like that. But generally, right to work laws are going to be prohibited under the PRO Act. There's a whistleblower section that also inserts a new section into the LMRDA that prohibits employers or labor organizations from terminating or discriminating against employees who report possible violations of the LMRDA. So that's just a whistleblower protection. I'm coming to the conclusion here. I think that we've really talked about a lot of the large scale changes that is outlined by the PRO Act. So the $1 million question is, will it become law? And I certainly don't have a magic crystal ball or anything like that to decide that answer. Certainly the dynamics in Washington are such that there's basically two paths forward here. One is reforming the filibuster, and there's Democratic senators who say that that's not a path forward for them, and then the other is reconciliation. To what extent can any of this package get done with reconciliation? That depends on determinations made by the Senate parliamentarian and things like that. The ULPs that get outlined, maybe they have a more than incidental impact on appropriation and revenue to the federal government. So maybe there's an opportunity for some of those to be included in a reconciliation bill. But that all remains to be seen. So I think anyone's guess is as good as anyone else's at this point. But it's clearly a political battle in DC. But I hope that I've done a decent job of going through the large scale changes. And again, I think that one of the benefits of looking at a large scale proposal like this is that it allows us to take stock as to what the scope of federal labor law is presently, and where we're at. So,
great presentation, Dan. Thank you for. As I listened to your presentation, I was wondering how many pages does the PRO Act actually encompass. That you got down to about a 40-minute presentation. Very nice presentation. By the way, a couple